Hello, everybody. Thank you for joining us today. We're just going to let everyone get into the webinar. This is going to be the next session in our new series on the new laws that are coming into effect this upcoming January that fall under the Minnesota Tenant Landlord section of Minnesota statutes. So today, again, we'll be started in just a couple of minutes, so sit tight while we let folks get settled in. This session is being recorded, so please be aware, and we'll be started probably in the next 30 seconds or maybe a minute. We'll see once the number of people stops ticking over so quickly. I'll get us on the move. Okay, I'm seeing a pause in the uptick of people joining in. So I think we can go ahead and get started. Welcome everyone to the August section of our new webinar series. This month we'll be covering fee disclosures, pet declawing and devocalization restrictions, move out and move out inspection requirements, and early lease renewal restrictions. So lots to cover. It seems like a lot, but these are fairly straightforward changes. Is the theory, at least. So we'll have our some of the folks who were instrumental in getting those new laws before the legislature. So we'll be joined by Shana Tomenes, who's a staff attorney at the University of Minnesota Student Legal Services, Zach Eichten, who is the state director at the Minnesota Humane Society, and Amma Carrion, who is the Homeline Supervising Attorney for our hotline. And I want to do a couple housekeeping things quick, just so that we can get that out of the way. This session is being recorded, just so you are aware. So should go through quick though first. What is Homeline, in case you're new here? We do have a lot of folks who have been joining us for the last, almost 3 years worth of presentations, these monthly webinars that we've been doing. But in case this is your first time, welcome. We do have so Homeline is a nonprofit. We serve the entire state of Minnesota. We've been around since 1992 in some shape or form. Then this past year, we just served our 300,000th renter through our hotline. So obviously we're many more than that now, but that was a pretty big milestone for us. We do offer our services for free in 4 different languages. That would be Somali, Hmong, English, and Spanish. This is our hotline. We also have an email and attorney option if folks prefer. So all this information will be available at the end of the slideshow as well. And then, like I said, the session is being recorded. We'll be uploading it to our website in a few days, along with a PDF copy of the slides. You can also find the recordings and copies of most of our previous webinar sessions for the last 3 years on our website as well. That's homelinemn.org. We will ideally have time for questions at the end of this. So we encourage you to submit your questions via the Q&A option at the bottom of your screen. Otherwise, I will miss them. We did have some pre-submitted questions that we'll try and cover if they're not covered as part of the overall presentation today. But if you do have a question, please submit it in the Q&A and we will get to it at the end of this. We love questions. We usually have a lot of questions that come through in this. And so definitely encourage you to ask them. All right. And then finally, for those of you who care, we will be applying for 1.5 standard CLE credits after this is finished. For those of you who don't know, if you're an attorney, you need to have continuing education credits. And so that's what those CLEs are. So then without further ado, here's the upcoming webinars, the continuing of our series. Next month, we're going to be talking about pre-eviction notices. And you can see that we have enough stuff still to cover for the entire rest of the year into January. So plenty more stuff up and coming. All right. And someone had a pre-submitted question about breaking leases due to infirmities. That is coming up. We will cover that in October. So hang tight. Join us then. You can go see more information and register at our website, homelinemn.org. Find the new laws section. You can register through there, and we'll see you then. Also, speaking of those CLE credits, we are hosting a full day CLE on these laws again. That's going to be Thursday, December 7th. Again, that's going to be a full day CLE. More information will be forthcoming, but wanted you to get that on your calendar now. If that's something that you need, it will be free. So that's a lot of CLE credits with a lot of good information about all of these changes coming up soon. Okay, I'm done talking. I'm going to change it over to Shayna, who's going to walk us through about move-in and move-out inspections and lease renewals. Take it away, Shayna. Thank you.
Hi, everyone. My name is Shayna Temenis. So I'm a staff attorney here at the University of Minnesota Student Legal Service. And both of these pieces of legislation that I'm going to talk about today were really propagated by University of Minnesota students and their undergrad student government. So while I am talking about a hyper-focused area, and there might be, tenants, landlords on this call who say, it never even occurred to me to do it a certain way, or this isn't within my business practices to do it. Just know that these laws weren't maybe necessarily meant for your area or for your practice or portfolio. Or as a renter, it might not be something that you experienced, and that's okay, because these are kind of very narrow, hyper-focused laws. And I'll try to go through each one. I know I'm a fast talker. I promised myself I was going to go slow, but if I say something that doesn't make sense, please let me know. I am happy to expound in the Q&A, anything. And if there's anything else we can do to support you, happy to help. I also say, and Rachel said it in the beginning, both of these sections start on or after, for leases entered into on or after January 1, 2024. So there's plenty of time. So this might be not the lease that you are currently living in under. It won't be effective for that. Or if you are having, new tenants sign a lease, if you're a landlord, it doesn't go in effect until that. But never hurts to change your practices now and to get ready for it. And then if you see on one side of the screen, I have what's called the text of the law, and that's to keep me honest, so you don't have to believe me and what my highlights are. But I think that that's a lot to read, so I also put the highlights on the other side of the law, just so everyone can see it and kind of understand what we're looking at here. So we're talking about renewing leases. So what that means is when you are going from, if you're staying in your unit and you're like, gee, I want to stay. If you're a landlord and you said, this tenant's great, I want them to stay. And the process and what that looks like contractually now under Minnesota law. There used to not be any rules on it. A pretty standard going rate was that most people went, said, hey, if this lease expires, we go month to month, or they say, 90 days out, let me know if you're going to stay or leave and we'll sign a new lease. That's pretty normal. Now, as way of background, in the area where I serve, which is in primarily the Dinkytown area and surrounding University of Minnesota Twin Cities campuses, that was not the practice. The practice was when you moved in September 1, then by September 30th, whatever year you were in, you had to decide if you wanted to live it the next year. So you literally had only known your landlord for 30 days. And we're deciding, sometimes even 15 days, and you were deciding whether or not you wanted to stay there for a whole year from now. So you were deciding on 24, 25 during 23. So this law is meant to address that situation. And what it says is, if you are in a lease that is more than 10 months long, so 12 months is a pretty typical one, but some people do shorter leases. The landlord cannot require the lease to be renewed during the first 6 months of the term. So what that means is if your lease starts September 1 2023, it isn't until 6 months later that you can have a renewal requirement, meaning, we're talking, what's 6 months from then, February. Then your landlord can say, you need to let me know by February if you are going to renew or not for the 24-25 term. And this can be less, like there's no new requirement that you have to do it 6 months before it ends. So if your standard practice as a landlord or your standard practice in your lease is that 90 days before or 60 days before your lease ends, that you talk with your landlord and decide whether or not you're going to be there and provide notice that you're going to leave. At that point, that's when you would decide. That's totally normal. You just can't do it in that first 6 months. It's kind of like a cool down period. You get to know each other. You decide if that's going to work for you both. And that is, could I have the next slide, please? So that's it for the first one. The second one is really about move-in, and then I have another slide about move-out inspections. And this is completely new. And it's codifying a process that many people already have in place, but it's more talking about what it looks like when you're moving into a new place and maybe there's issues going on there. And then also when you're moving out of a place. So it creates an affirmative obligation for a landlord to inform the renter of the right to request a move-in inspection. And this move-in inspection, you need to either tell them no later than 14 days before the lease starts. So an easy way to either be put it in your documents when they walk in the door, pick up the keys, here's a flyer, but you have up until that 14-day period to inform them their right to a move-in inspection, and it's a tenant rent. And it just, all you have to do is let them know, hey, you have a right to a move-in inspection, talk to an attorney, they'll help you write something real nice. And it's just, you want to make sure that they're aware of this. If a tenant if your tenant wants an inspection, then they request the inspection and it's held at a time that's mutually convenient for you both. And in this inspection, really what you're going through is, one, is there any issues? Like, your tenant wants you to know, hey, there's a big scuff on the kitchen floor. It doesn't do anything other than be really ugly, but you should be aware of it so you don't try to charge me when I move out. It can be to start to address some of those habitability issues, sometimes that people don't know about when new renters move in. So if you're a renter and you're opening the door and you realize, wow, this fridge does not work and this is a real big problem. One, you want to make sure you put in that maintenance request, but two, you have a right to a move-in inspection and you can have someone physically come in and check out that piece as well, as opposed to maybe putting it on a portal and having issues. You have this secondary right that is in addition to your right to put in a maintenance request. If, however, you're okay with it as a renter and you don't need to have someone come in and do an in-person walkthrough of your unit with you, you are allowed to agree on, hey, landlord, thanks for letting me know I have a right to have a move-in inspection. I'm okay with just taking pictures. Here's my pictures and my videos of the place when I moved in. This is the state of the condition of what it is. And while that seems like a lot of work when you're moving in, it's super important, especially when you're paying a security deposit. You really want to know what the place looks like when you move in, so that way you don't get charged for anything when you move out that you didn't cause. So any damage you caused, you also want to know what it looks like as far as cleanliness. So, if the place is really dirty when you moved in, one, you want to make sure it gets clean to your standards. But two, you want to make sure that everyone is aware of what the place you got looked like, and there isn't any, false expectations on move out. Just something to be thoughtful of, and it's just a good practice to have. And now it's effective for new leases. And then could I have the next slide, please? Okay, and then move out inspections. So this is what happens when you're moving out of a place. So again, it creates an affirmative obligation for a landlord to inform your outgoing tenants of the right to request move out inspections. And that's your only obligation, is to say, hey, you have a right to a move out inspection as a landlord. Tenant, your right is to say, hey, I want a move out inspection. I want someone to be there with you. If you decide you want to have a move out inspection, I highly recommend having it. it can be held no earlier than 5 days before move out. So if you're moving out the 30th of August, by August 25th is the first day you could have it. It'll allow the landlord to go through with you and communicate any issues that they see at the property. So this is a time for you and your landlord to walk through and they say, oh, look, I see all of these stickers on the wall, and I'm going to have to charge a cleaning lady to come out and rub those off and get rid of them if you can't clean that off. And then you go, oh, geez, I completely forgot about those stickers. Those were my fault. I apologize. Let me get those cleaned. That way you don't charge it against my security deposit. It also means that you can clear up any miscommunication. So if you're saying something like, the landlord says, this is a dented in microwave. I don't know what you did to this, but this is not acceptable. I'm going to have to charge for a new microwave under my security deposit, against your security deposit. Then you can say, oh, no, that wasn't me. That was here when I came. And it didn't cause any problems with the microwave, and I just let it be. Here's a picture of when I moved in, and this is what it looked like. And then they go, oh, geez, okay, I didn't realize that that's what that looked like. I didn't know that this is what we're looking at. No problem. And you should definitely see this as a space for open communication and dialogue around that. And the goal of it is to prevent any accidental or wrongful deductions from a security deposit. So people don't have to, try to chase down the rest of their security deposit from a prior landlord when it was really just a miscommunication and a misunderstanding. You also don't have to, as a tenant, request that inspection if that's not something you think you need or something you're not interested in doing at this time. The law says you don't have to do that. It's an optional thing. And then landlord, if your tenant doesn't want that or doesn't need that, they are discharged of any obligation. And then it just goes back to the rules under Minnesota statute section 504B.178, which is the law on security deposits. So that's really the different pieces of what goes on there. But that's all I had to say. And if anyone has any questions, please feel free to put them in the chat. And it was great to talk to you all.
Awesome. Thank you very much, Shayna. All right, I'm just popping in the link here in the chat for everyone for that statute that Shayna just talked about. And then we'll go ahead and get Zach Eichten. Here, again, he is the director for the Humane Society here in Minnesota, and he's going to talk about a very, very specific new set of rules. So there will be some cute animal photos in here, and maybe some not so cute animal photos in here. So please, Zach, take it away.
Awesome. Thanks, Rachel. Hi, everybody. My name is Zach Eichten, and I am the Minnesota State Director for the Humane Society of the United States. We're an advocacy organization that has a presence at the federal level and all 50 states, specifically working on animal-related issues. And my background actually is in housing work. I used to work for the Minnesota Coalition for the Homeless here in Minnesota, working in the policy space. So I was really excited to be able to work on pet declawing and devocalization prohibitions as it was introduced before my time getting over here. And it was something that we were able to pass once I joined the team last year. So we can hop over into the next slide and talk about some of these pet protections for renters. So essentially what this new law is really looking at protections for pets and people and property. So just for a little bit of context, why the Humane Society cares so much about declawing. Declawing is unfortunately not just like trimming nails. It's actually an amputation of a cat's fingers. So if everybody were to look at your hand right now, declawing is essentially if you were to take the first knuckle off of each of your fingers as a way to stop from having to ever trim your nails again. So that's essentially what declawing is. It's a pretty it's pretty difficult to look at when you see pictures like this, and it is a partial digit amputation. So that is what we're talking about when we talk about declawing. So why is it bad for cats? Essentially, it causes a lot of long-term health issues. So you can see all the stats here, but the ones that are most important, I think, in this context is cats that are declawed have long-term complications, but they also have behavioral displacements that can be really bad for a property, including being 7 times more likely to avoid the litter box if they're declawed. Because of the texture of kitty litter, it can be very painful to step on if you are a cat that has been declawed. So essentially they will go basically anywhere but the litter box. So if you are a pet-friendly landlord that allows animals in your property, what you might end up with is a situation where the property is left off in a lot worse shape because the cat goes to the bathroom basically anywhere but where you don't want them to go. And then of course it is also they're more prone to biting and stuff. And then I don't have a specific slide in here because it's so much less common, but dog devocalization was also included in this new law. And devocalization for a dog is essentially surgically altering or removing the dog's vocal cords to make it so that they're less likely to try to bark. However, that also comes with behavior displacements as well. And they're much more likely to have aggressive behaviors because they've lost a form of communication that is typical for dogs. So both the cat declawing and dog devocalization are these essentially cosmetic surgeries that can lead to pretty severe displacement behaviors that we're trying to avoid and can make a property less inhabitable for future tenants. So as we look at Minnesota's new law here, essentially we were trying to protect pets, we're trying to protect property as well. So given the sort of permanence that you see for these surgical procedures and the temporary nature of rental occupancy, we wanted to have some sort of step in here and have some sort of protections in place. So here's the quick cliff notes for what the law does. But essentially it makes it illegal for landlords to advertise or require declawing or devocalization of an animal as a condition of pet tenancy. This does not in any way require landlords to allow people to harbor animals as pets, other than anything found in the ADA or Fair Housing Act. This isn't saying, okay, you have to allow all animals and they have to be not declawed or devocalized. That's not the case. We use the new law also defines animals using an existing statute to do that. There are some civil penalties we'll get into. And then, of course, as I mentioned, landlords are allowed to continue to have contracts and rules in place, making tenants liable for any pet-related damage or any behaviors that the pet has. So we can go to the next slide and get into the specific law here. So looking at definitions on Minnesota's new law, these can all be found. The law, if you want to take a look at it, is in, I'm sure, Rachel, you're going to put this in the chat too for folks, but it is in section 504B.114. Going to verify that. Yeah, section 504B.114. So you'll be able to pull that up at your leisure when you want to. But essentially, application for occupancy is all phases of applying for the right to occupy property or filling out lease applications. And then clause and declawing are put in there as definitions, as well as devocalization. As I said before, devocalization is far less common than we find with declawing, but those are both defined in the statute as well, and you can see those definitions here. So we can head over to the next section of the law, which is the actual prohibitions that are found in the new section. So this is really the sort of the meat of the new law. So what we're asking, what we were able to pass is prohibitions on advertising the availability of any property that's designed to discourage the application because an animal has not been declawed or devocalized. So if you allow pets, you're not allowed to put in the in any sort of advertisement for that lease anything to the effect of declaw encouraged, or non-declawed cats may not be included, or anything like that. Then refusing to allow the occupancy of that real property, or refusing to negotiate or otherwise deny a person based on that would be prohibited. So again, if you already allow animals, you wouldn't be able to specifically deny an animal just because a person has not declawed or devocalized that animal. And then you would not be allowed to require existing tenants to declaw or devocalize animals if they're already in the premises moving forward. So those are the three new prohibitions that are put in place based on this new law. And then finally, there are some penalties. They're designed to be pretty low stakes penalties overall, just as a warning and a reminder for folks that this law does exist. So a city attorney, county attorney, or the AG could bring action to get injunctive relief for a violation of any of these sections. And then in addition to any other penalties that could be found in other parts of statute, any advertisement would be $1,000 per advertisement, up to a max of, and then any actual animals that are harmed, it would be a violation of a fine of $1,000 per animal as well. That would be paid to the entity that's bringing the action. So those are the penalties. Ultimately, what we're trying to do here, which is, and why we were able to get a lot of buy-in for this new law from sort of across the board, is that we're protecting pets, and we are also protecting the property as well, because with the sort of behavioral displacements that occur when these elective cosmetic surgeries are performed, it can make property have a way worse after effect than if you were to just allow animals to have their all of their digits in place in the first place. So that's sort of the end of what this new law is doing. Like Rachel said, it's a very specific new law. And I see that there may be a few questions in the chat, and I'm looking forward to answering them as we get to the Q&A.
Fabulous. Thanks, Zach. Yes, so as Zach pointed out, please give us your questions in the Q&A section of your at the bottom of the Zoom. Keep them coming. We'll get to them. We only have one more section left, so bring them on. I'm trying to also put links to everyone in the chat for the various rules and laws that we've been talking about. The session law, so like the one that Zach was just talking about, is actually a new law. There's no section 504B.114 yet. So that is currently housed in the session laws to get a little bit in the weeds of how this whole process works. So I put a link to the session law that has all of the things that passed here in this last session. So you're going to have to probably do a find for like declawing or something like that if you want to get to this specific section. Otherwise, you'll be scrolling for what will feel like years. So, but speaking of new things, we are going to shift a little bit to fee disclosure requirements. So this is something that has gone through several iterations. And so Amma, who again is the one of the supervising attorneys here at Homeline for our hotline, she is going to talk about what we mean by this.
Hello, all. So fee disclosures. How it stands right now is that leases need to include any fees that the landlords are going to charge. So late fees, pet fees, etc. The issue is that, and why there's a change in the law, is that we really needed clarity in advertisement. The true cost of renting wasn't really clear. And there was this tendency for landlords to start charging mandatory fees or non-discretionary fees that really hid the cost of rent. I keep referring to this as the budget airline model of sort of setting up a price for anything. So what the new law requires is for landlords to disclose all non-optional fees on both the front page of the lease and in any advertisement out there. And it has to be called the total monthly rent. Next slide, please. So what does that look like is that the tenant will get a lease and see all the mandatory fees. The rent calculation has to be listed in a very obvious place, very easy to find on the lease. And again, it's just that the industry standard was really taking this bait and switch mandatory fee system to artificially lower rents, when in reality, the rents were what they were higher. An important note here is that lease renewals are also covered by this law. Generally speaking, on term leases, tenants, this is sort of the most common one, is a 60-day notice. The tenant will get a notice from the landlord telling them, hey, do you want to renew your lease? But tenants didn't know how much the lease renewal was going to cost. So this has to be included now in that lease renewal, like rent is going to be X amount. And that gives the tenant time to figure out if they can afford to stay there. So the total monthly rent calculation is all mandatory fees that are not already included in rent. So if the landlord has a payment portal, that needs to be included. And it's the tenants are forced to use it because they don't accept cash or check. You can go to the next slide, please. Same goes for any administrative fees. This is very common for buildings or properties where the landlord charges utilities. Amenity fees have to be included. The utility fees, if they're charged by the landlord. Internet and cable has become pretty common to be included, and tenants can't opt out. So that's basically it. Think of it as discretionary and non-discretionary. What's a discretionary fee? Pet rent. Tenants don't have to have a pet. Parking, usually if you don't have a car or you don't want a garage spot, you don't have to pay for parking. Just things like that that are, the tenant has an option to have or not to have. Storage units. Next slide, please. So here's an example of what this looks like. Let's say the landlord has an ad on Craigslist and says that the rent is $1,000. Tenant goes and looks at the unit and they like it. The application fee is $30 per person. There's going to be 2 tenants in the unit, so $60 total to apply. The tenants have looked at the rental at the end of the month because that's when there's most availability due to unit turnover. So there's an opportunity cost there. And the prospective tenant doesn't apply anywhere else, again, due to the opportunity cost, because they really, really like this unit. And they also might be locked into the application since there's some landlords that do have a non-refundable hold fee that if the tenant gets approved and they don't agree to sign the lease, then they forfeit that money. And it's usually a substantial chunk of change, from $300 to $1,000 I've seen them. So that's a big deal. So what the new law requires the landlord to say is like, look, rent isn't really $1,000. Rent is going to be $1,000, and then for this month there is this fee, and then there's all these other things that you're going to have to pay for when you're living with us. So there's going to be the $6 for the tenant portal to pay rent. There's going to be, we include cable and internet, yay, but you can't opt out of that. We include garage parking, but you can't opt out of that. So those fees have to be included in this $1,000 of rent a month. Next slide, please. So to summarize the whole shebang of the law, the current issues is the mandatory fees. Tenants really are just unable to budget right now and see if they can really afford the units that they are applying for. They tend to only see the total cost of rent with fees the day the lease is signed. And if really they're lucky, after they're approved, so there's usually like from the application a 2-day to 7-day gap. And if they don't sign, they would lose that hold fee, which is a big deal. There's also the application fee that would be lost by them. Then there's also the lost chance to look and apply for other units that might be available and they might like during the time of the month where most rentals take place. So the new law puts an end to this practice, this sort of industry standard of bait and switch, and it requires disclosures of all non-optional fees, again, on both the front page of the lease and transparency in advertisement. So that Craigslist ad needs to list what the real total rent is, not this model where the base rent is this, and then there's other stuff that we're going to tack on at the end. Next slide. So I think the best way for landlords to handle this, the easiest way and the best business practice model moving forward, is to not charge mandatory fees. Just really lump it into the rent that the tenant will owe every month. You know, ultimately, that's what tenants want to see. They want to see, this is a 2-bedroom unit that I like in the town that I like, and it's going to cost me $1,800 to rent it. And that's what I'm going to be able to budget for. So if landlords just lump everything into the rent, they're complying with the law, tenants can budget, and then no one really starts feeling like they're being taken advantage of, which is unfortunate, because we do get a lot of calls where people feel like they've been had. And that's actually all on fee disclosures.
All right, thank you so much. Okay, so we have quite a few questions that have been put into the Q&A, and again, they'll keep coming, and that's great. I want to try and do a couple of the pre-submitted ones quick, just to, you were kind enough to pre-submit them when you registered, so we will touch on those first. So then a couple of these don't specific, they're just like general tenant landlord law questions. So I will go ahead and try and tackle those. Or I may open it up to the group as a group think if it's a more complicated or question I haven't really thought about before. So let's see here. Jessica is a service provider. And so they're talking about Minnesota, I think, domestic violence versus VAWA protections and pet cleaning fees for EMAs, which is, I believe, emotional support animals. And so the general rule when it comes to emotional support animals is that they landlord cannot charge additional money or have additional requirements or restrictions on an EMA. It is, think of it as like a prescription. So say you had a prescription for a epilepsy medication or something like that. Your landlord couldn't put in restrictions saying, well, you can only, you can't have that here, or okay, but you have to pay an extra $50 a month in order to have that prescription in your apartment. Same thing. So that emotional support animal is essentially a prescription. And so no limitations and no additional charges can be associated with that. Then, all right, so the next one, Maria from one of the HRAs, I believe up north, I wanted to know, there's a landlord trend to charge fees, software fees, bank draft fees, other fees. Are these fees CRP eligible? Amma, I know I sent you on a chase this week.
Yeah, this was actually an interesting question. So the short answer is we don't know yet. I called the Department of Revenue, and after being on hold for an ungodly amount of time and them going above and beyond to figure this out, they just don't know yet what administratively they are going to do with what's included in the CRP. There's two ways of looking at it. One is it's not rent, so it doesn't have to be included. However, because it's a non-discretionary fee, technically it could be rent. So what they've suggested is that people go to their website at the Department of Revenue, I think it's departmentofrevenuemn.gov, but don't quote me on that. And you can subscribe to their mailing list, and there's a specific one for CRPs. They issue a guidance sheet for landlords every year. There's one for the CRP that's supposed to be for 2023. It's going to come out towards the end of the year. And then that's going to have the very specific information of whether it counts for the CRP or not. So I am sorry, I was unable to get you a clear answer, but they just don't know yet.
All right. So great question, and more info to come. So, and also thank you so much for submitting that question early, because we at least were able to get a little bit more research done into that one. You had asked about infirmity laws. That is coming up in October. So again, please register for that upcoming webinar session, and we will talk all about it. The next one is Eli, who's a tenant, is wondering what happens to a security deposit when the property management changes mid-lease. I'll take this one real quick. The security deposit is supposed to, if it's just the property management, nothing really should change with your security deposit if the ownership of the building doesn't change. If the ownership changes, then one of two things is supposed to happen. The security deposit either transfers to the new owner, or the old owner returns the security deposit to the tenant, and then the tenant and the new owner have to work out a new security deposit exchange, I guess. Let's see. Sarai, I believe, is a landlord or with a landlord property management company, and they were just talking about move in, move out cleaning. So I don't know if there's any kind of guidance in the new statute or anything like that about cleaning, Shayna, that you want to touch in on?
Sure. And to be clear, everything in the new move in, move out statute doesn't affect your obligations as a renter or as a landlord under 0.78 on 504B. So really, when we're talking about cleaning, the time for this move out inspection is going to be about identifying defects. And so if you are, as a landlord or a landlord agent, are walking through a unit and you see a giant stain on the carpet, right? Like it is 3 cups of coffee of trouble. And you say, that's 3 cups of coffee of trouble. That's brand new. They need to fix it. And if it doesn't get fixed, we're going to charge it against your security deposit. That discharges your obligation. It's really more to identify really obvious things that maybe could be fixed, right? That, maybe somebody can get a really nice shop vac in there to fix it and it looks okay. But that's really the goal, is to have that open communication of things. I saw another question in the chat. I'm sorry if this is not following the right protocol, Rachel, that was talking about like the frustration of if you're trying to do move out inspections and you see like a bunch of dirt and debris and you feel like you can't have a real conversation about that. Just know that it's like, moving out is very difficult for everybody, right? Like everyone has things half in boxes. If you're anything like me, when I'm moving out, I am packing the day that we're leaving still. And that's okay. The goal is to really identify those problem areas, and you don't have to modify. If you have like a move out checklist, it doesn't require you to modify that checklist. You can just go through key things. It's also an opportunity, renter, if you have something that you're worried about, if you're like, look, I want you to see this. This has always been broken, and I've talked to you multiple times about it. Please don't charge me for this. That's that open communication. The beginning of, and why this was really pushed for by University of Minnesota students, was they felt during turnover, which was, in a university district like Dinkytown, or, maybe up by UMD in Duluth, that people are turning over significantly more units than even the traditional model is. So they're turning over maybe 600 units in a 605 unit building all in 2 days, and that they weren't able to get some of those issues addressed, and that it was ending up in a small claims court action. It was ending up with people being wrongfully charged wrong amounts of money. So this place is to prevent those issues and to just put in a practice that a lot of landlords already do on the front end.
To that, I want to add, and this is both to landlords and tenants, it's always important, like when you move in, take pictures and video of the conditions of the unit and when you move in, and also when you move out. So when you hand in the keys. So the move out inspections are great. Move in inspections are great because you know what are the deficiencies that are present. Cleaning, it's one of those things where it goes into wear and tear, right? and then just the regular cost of turning around the unit. And I know there's a question here that talks about a landlord being unable to see walls, floors, etc., due to the tenant stuff. Just know that you still have a security deposit. You still have the ability to make deductions to it, and you just have to justify it. It's not just you walk in when you're doing your inspection and you're like, oh my God, this is a mess. There's so much trash everywhere. I'm like, well, yeah, I mean, they're moving out. That doesn't mean it's going to stay there. So be aware that moving is awful and that you have some people that are okay with just not cleaning so that it gets deducted from the security deposit, but there are a lot of people like me who are psychotic about it and will make sure that it's super duper clean before they hand in that key.
Thank you both. Okay. So then Amber is a service provider and wants, this is a question for me quick about accepting emotional support animals when tenants get them without going through the proper channels first. So proper channels is a maybe a misnomer in this situation because there is so a reasonable accommodation request is essentially when you request a landlord or a housing, HR or whomever is providing the housing to have an exception to a existing policy or rule. So if it's like a no pet policy, then you're asking for an exception to that so that you can have your emotional support animal. And so there is no timeline to that. There is no formal paperwork. There's no like legal document that has to be submitted as a part of that request. There's a lot of information that HUD has about these things, and I am going to link to that at in the chat here. But essentially, like the landlord, if you have an animal already and you make the request, we always suggest you do that in writing. Just to give a heads up and say I'm making a reasonable accommodation request. There are some rules around what a landlord can then request as a kind of backup, backing up your request for like medical documentation from your medical provider. So that's 504B.113. So, but this is what a landlord is limited to being able to ask for in association with an emotional support animal. And that is, and I also want to make clear, not the same as a service animal necessarily. They are kind of a subcategory of service animals, as it were. So they often perform similar functions, but sometimes service animals will perform other functions as well. So there's a lot to it. That's a complicated question.
Yeah. And Rachel, while we're on this topic, Sarah has a question in the Q&A that I think flows into this pretty well about
Sure.
The decline and devocalization, and would that apply to a reasonable accommodation request? Yes, the answer is if there is a Fair Housing Act or ADA requests for an ESA or service animal, that decline and devocalization prohibitions would still apply to those animals that are covered under that section of law. So yes, it is still covered.
Perfect. All right. Next question we have real quick is which one? Okay, Clay is a landlord, and this is actually for Zach. So Clay is a landlord, and they want to know if you have any suggestions of how to approach tenants about animals who are barking and whining, especially when other tenants are in the same building are complaining. Like if you've got that dog, that neighbor dog that just will not stop.
Yes.
How does a landlord approach that?
Yeah, no, and that really is a great question. So thanks, Clay, for a really great question. What HSUS, our position as it comes to pet-friendly housing is we want to encourage responsible pet ownership. And one way that landlords can really help with that is having very clear rules around pet policies. If you have pet-friendly housing, when somebody signs a lease, so that everybody is on the same page. When you are bringing an animal into a shared living situation like multifamily housing, that everybody is aware of what the rules are, whether it's leashing requirements, nuisance requirements, picking up poop around the outside of the apartment, all of that stuff. You have really clear guidelines for, and if you want help, please feel free to reach out. We are happy to help with that in any way to help develop a strong set of guidelines that you would be able to use. But really just having those expectations clearly laid out at the beginning is the first way that it will make it easier to approach those folks who may have that barking dog. I mean, I know this is Minnesota, so some people hate to ask people to stop doing something, but as a landlord, you're going to be in that position sometimes where you are going to have to make corrective ask of people who maybe they're working all day and they're not at home and they don't know their dog is barking. Provide a little bit of grace to correct the problem first would be our suggestion, but absolutely having really clear guidelines in place will make that conversation a lot easier. Yeah, just if you do have any questions about that, please feel free to reach out. HSUS is happy to help provide a list of what would be considered reasonable rules or expectations that landlords would be able to implement in order to convert to pet-friendly housing.
Thank you for all that. All right. Gloria asks, Zach, quick, basically your entire portion of the presentation was, can a landlord force you to have your pet decluttered, devocalized? So we don't really have to go over that again.
As of January 1st of 2024, no, I can't.
Perfect. Carla is a tenant and is wondering if video recording and taking pictures of unit is the best legal way to prove no damage. So I guess that's really an opinion question, but.
No. So I love photo and video. I think that what's really important, and people are doing a really good job at move out, they're thinking about it. But what I've found when I go in and I'm working on cases where someone is having a dispute about a security deposit is if when you're moving in, like the first thing, you unlock the door, you open the door, you have a video going, you have pictures of different things as you open and close different cabinets and appliances. And then you can compare that to and do the exact same thing when you move out. That really shows both the standard that you should put it back in and what it looked like when you moved in. Do it in conjunction with whatever, if they have a checklist, and you can always ask for a checklist as a renter. Say, hey, do you have a move-in checklist? Compare that with the checklist. So if the checklist says microwave's clean, you open the microwave, you take a picture of the inside of the microwave, great evidence. I also always say if you can, keep it on somewhere other than your phone. Keep it on like the cloud, keep it somewhere so that way your phone doesn't meet a snowbank in the winter and you don't have your photos anymore. So I would say that's a really good thing. That's something that in my experience that referees look at and consider. And it's often, you know, your landlord, that's their standard practice to also take photos and videos when you move out. So then you are both looking at the same thing. So maybe they have a close-up of an area, but you have a further up picture of it. And that gives a better context of the dispute. Really important to have.
Awesome. Thank you for that. And then we had 3 other questions from one from Monet, one from Jeff, and one from Lola, who are all tenants, I believe, asking some very specific questions about their circumstances. What I'd recommend you do, actually, you 3, is call us directly or email us, and we can talk about repair issues or specific security deposit debits or lease questions that are specific for your circumstances. We keep to general information on these sessions, excuse me. Perfect. All right, and so that is it for the pre-submitted questions. So now we have several in the Q&A. Again, I really highly encourage you to ask those questions, start the discussion. We have 3, 4 very smart people here who would love a rousing discussion on things, you know, regarding these. So I'm going to just start at the top and work my way down. So first one, Amma, you had said, do you want to answer this question? But I'm actually going to kick it to Shayna first. So the question was from Anonymous, and they want to know, what if the tenant only signs a 6-month lease? Can we not request renewal until when their lease ends? Or does that only apply to a year lease?
Great question. So it only applies to leases longer than 10 months. So in your 6-month lease, this law doesn't apply. You have contractual rights to go through that. So it's 10, 11, and 12-month and further on leases.
Okay. And Amma, since you grabbed this question, could you mark it as done so that it can, perfect. Thank you. Next one is from Erin. Shayna, you said you wanted to answer this question, and I'm going to keep it in your field. Is the inspection just with the landlord or their agent?
Yes, so it can be landlord or their agent. So it can be your property manager. It can be someone else who is their person. An agent is it's like a legal term that means a lot of different things. It just means somebody who works for your landlord. If you have specific issues or concerns about that, definitely seek legal advice if you have like problems and you're worried about the person coming into your house.
Right. And then if you can mark that as done, because again, you marked that one. All right, perfect. So next question is also for Shayna. We're just gonna keep on the Shayna train here. John Buda is wondering if there are any consequences for landlords if they fail to comply with the move-in, move-out inspection requirements.
No, okay, all right. So I should have put that in there. Thanks for keeping me honest, John. So yes, so under 504p.178, which is the like security deposit provision, there's a section in there around damages where, you know, tenants can get additional money if things are wrongfully taken out of their security deposit. This section is added into that, and the specific language around it says that you know, a landlord who fails to provide the tenant with notice for the initial inspection and move out inspection as required, and complete an initial move in or move out inspection when requested by the tenant is can be responsible for not only the wrongfully withheld security deposit, but the double amount as an additional penalty.
Okay. And so the next one is the one that we've been kind of alluding to, but I just want to make sure it's very clear. I'm going to ask the last part of the section. If we find more damage, if the landlord finds more damage after a tenant moves out, can they still charge a security deposit for that damage that wasn't necessarily apparent during that move out inspection?
Yes, of course. This is all of the obligations under 0.78 have not changed at all.
Thank you for that. Okay, John has another question, this time for Amma. So Amma, other than requiring disclosure, does the new law, I'm assuming they mean fee law, say anything about what type of fee a landlord is allowed to charge? So like, does it prohibit any kinds of fees from being charged? Like January fees is a favorite around here.
So no, the law doesn't prohibit the types of fees. Just know that how it works is, for example, late fees. There are certain provisions in the law that include how to deal with specific fees. So there could, with the January fee, which I'm not entirely sure what it is. What is it? Rachel, do you know what that one is?
Oh, it was one that was being charged by a landlord.
Oh, now I
at one
remember
point
what it
that
was.
was just because it was January, and so it was called the January fee.
So that January fee, now I remember which one that is. That would be basically that administrative fee that's charged once a year. So how you would do that, and I had a slide on it, or a part on one of the slides. It basically, say it's $300, 12 monthlies, you can charge it, but it basically you have to include it in rent as divided by the 12 months in the year. And then other fees like late fees have to be included in the lease, and there's a specific statute that addresses that. So basically landlords can charge whatever fees they want. They should just roll them into the rent.
Maybe the easiest way, but the goal is, there's no prohibition on fees. It's just that it needs to be disclosed up front in both the advertisements and in the leases before someone signs it as to what their monthly costs are actually going to be.
And like, I mean, with this January fee, if I remember correctly, like people just have to pay it in January. So, I think how I would do that if I was a landlord and I was desperate for this January fee, I would say something like first month rent is $1,300, going with my $1,000 example on Craigslist, and then subsequent months rent will be $1,000 because you've paid that fee. or give the tenant the option of, you'll pay $25 a month or however much it is over this fee. Now, I guess what we're trying to do here with this law, because this was something that our managing attorney of the hotline worked on really hard, is to get rid of this idea of just charging fees for no good reason.
Or even for maybe good reasons. I mean, like, these are certainly costs of doing business. It's just that
is an administrative fee. You can roll it into the rent. I think we want to be clear with the tenants that this is what it really costs to rent the unit.
We talk to tenants all the time who say, well, because one of the questions we ask a lot is, well, how much is your rent per month? And they say, well, it's, $1,100, but once all the utilities and the fees and everything come up, it's actually $1,500. And, that's a lot, that's a lot of money.
Yeah.
That's a big difference, especially in a budget when, you're trying to figure out what it is you're going to be paying. So it does really happen. It's not that all landlords do this. A lot of landlords do just roll all of their costs of doing business into one rental fee, and that's easy enough for them, but not everybody does. And it was so awesome. Thank you for that rousing discussion, John. Okay, so Anonymous is asking, I think this is more fee stuff. Might be more specific than we can really get into, but our payment portal gives 3 options. ACH from bank is free, debit card is $3.95, and third-party processor and credit card is 2.5% charged by a third-party processor. Which one would be included in the total monthly rent?
So what you would do if these are the options that you have, you would say, total rent, if you do the bank withdrawal is, it's X amount. If you do payment through debit card, so you'll do the rent plus the $3.95. And then the other one would be, whatever the other amount was, because I can't see it anymore.
It's at the very top of the questions.
The 2.5% charge by the party processor. You do have to detail it. I know that it's just kind of going to look weird on the applications and the advertisement to have this look so choppy, like these are your options. Very much like with airlines, you want extra leg room, you pay extra. So again, this goes back to rolling it into the rent. I know with these particular fees, with this question here, it makes sense to break it down because the tenant does have 3 options. And so that wouldn't look ridiculous. I think what looks ridiculous is when you have like 10 non-discretionary fees and you have to list them all.
Yeah. Or what you could do is just say that, rent includes whatever, the 2.5% or the 3.95, whatever the higher of those 2 fees is. And if you pay by ACH, you get a discount each month. That's another way of doing it, to try and incentivize the tenant to pay the ACH instead of going through these third-party processors. So, yeah.
And we understand the reason that there's a sort of passing the cost of the tenant for using the third-party processors because it's a real cost. And it's happening with stores too. So we're not trying to say landlords you're being awful by doing this. It's just a cost, and it's okay to pass it on to the tenant. It's just be very obvious and clear with the tenant that this is a cost that they're going to have to pay for.
All right. So Anonymous is also asking, does the disclosure law and characterization included mandatory fees as total rent change the analysis for which fees can be the basis for an eviction if not paid or calculated into late fees?
So it depends, right? Total rent means total rent. If it's a non-discretionary fee, it means it's rent. And so it would be part of the eviction filing. However, if it's rolled into rent, not not a separate piece broken down, you just say, look, rent here inclusive of of everything, you know, of the cost of doing business is $1,300 a month, and that's makes it easier for landlords, right? Basically, you just file your eviction with that amount of rent, and you don't run the risk of the court perhaps nitpicking on the matter. And the reason is this is a new law. We don't know how the court is going to react. I can tell you as a lawyer what I would presume they would do. But, you know, it has to be litigated for us to really know.
Mhm. Stacy wants to know if an application fee could be considered a mandatory fee since you have to apply for it.
No. You know, it's not part of rent. It's a one-time fee, and you just know it, you know, when you apply. And
Yeah.
so if it's something that you're paying every month or every year, then it would have to be included in rent, but that wouldn't be part of the total monthly rent.
Good question, though. Back to Shayna. Does the move out inspection have to be before the tenant moves out? So they cite the current statute language, which says at a reasonable time, but no earlier, or no, sorry, the new statute language that says at a reasonable time, but no earlier than 5 days before.
Anonymous, are you an attorney? I love that. No, so unfortunately, it's like considered a series clause. So what the law says is at a reasonable time, but no earlier than the day before the termination of the end of lease days. And then there's a comma, and then it says, or day the tenant plans to vacate the unit, comma, which means that it's a separate holdout. So it can't be more than 5 days, can be the last day, but that's kind of your window to do it in. Obviously, maybe you disagree with me, maybe a judge disagrees with me, but I think that that's what that means.
Some of the funness of statute interpretation is there will be grand arguments about the placement of a comma at some point in a courtroom over this. Sarah is wondering if all the fees are included in the rent, that could cause problems with meeting affordability standards for vouchers, etc. Was that a concern that's been raised?
I do not know if that's a concern that has been raised.
The problem with it, I would say, is that it's still a cost that this
Yeah.
tenant would have to pay. And if the voucher isn't going to cover it, like,
they can't afford it.
Yeah.
I mean, that's sort of where it would end up going in terms of, you know, the Section 8 vouchers, for example.
But it's a really good question, honestly.
Though, just know that there is a way, and I'm not at all an expert on this, but for Section 8 vouchers, there is some documentation a tenant can provide to justify going over the 30% cap. So that's something they would have to talk to their Section 8 worker, because there is a way, there is a process for doing it. I just don't know the specifics of it.
Okay. And I guess to be fair, under the language of it, it's not that landlords have to roll those fees into rent anyway. They just have to, you know, make sure that they're upfront about what's included on a monthly, like what the cost of the monthly cost, sorry, how much it costs to actually stay there in a month.
And the thing, but that will affect definitely the voucher affordability standard, because if it goes over your 30%, then you can't afford it.
Yeah. All right. Anonymous, or at least this anonymous, is a social worker. So they're pointing out that there's a large property management company in southern Minnesota that has a section of the lease that says every tenant is charged $100 at move out for carpet cleaning. They think it's charged against the deposit. This is just an example. So would this carpet cleaning count as a fee?
Yeah, I mean, it's a non-discretionary fee that they want to charge, and this has been an issue for a while. Whether, you know, language on leases that says that you have to provide a document of professional carpet cleaning, or they'll do a deduction, whether that applies. And I think thoughts are mixed on this one. But yeah, moving forward, that's just basically, it's a non-discretionary fee. It has to be included.
Perfect. Another anonymous who I believe is either a landlord or property manager saying that if we charge a garbage fee that is allocated among residents by a third party that equals total garbage charges for the property, how do we disclose that? So if the
So
landlord doesn't know what the charge is going to
Right.
be.
That would be very similar to sort of the RUBS system. So that's what you would explain to the tenant. Utilities, and this would fall under the utility because it's garbage, sewer, etc. You would basically tell the tenant, look, this is the average that we have during the year. So you can do rent will vary between this and this. And this is the allocation that we have on the lease, which is a requirement of the law on how it's subdivided amongst tenants and units. And so it's amount of people in the unit, usually the square footage, and that's it, actually, usually. But basically the lease has to detail that. And you can just do an average. Rent will be on the high end. The past year, it was this.
Yeah, the 504B.215 subdivision 2A already exists, and that details how you would need to disclose that information in a lease anyway. So I cited that in the chat. Perfect. All right, I think that there may have been a typo in this. Anonymous is saying, how would returns insurance? I think they meant renter's insurance be factored into this new law.
Into the fees?
Otherwise, I don't know what returns insurance is. So if someone can enlighten me, that would be great. But I think they mean renter's insurance.
So how renter's insurance works is that tenants either provide evidence that they have renter's insurance, and if the landlord has to just, the tenant doesn't provide the evidence, then the landlord tax it onto the rent. So what you would say is, tenant, if you provide the certificate of your insurance company, your rent is X. If you take it where we provide the insurance, then rent is Y. Again, we're talking about transparency and what the tenant is going to have to pay in order to live in the particular unit. And that's what you're going to be offering. This is option A, option Y, etc.
Yeah, and the there may be some argument to say that that's a discretionary fee, since the tenant has the ability to, or they should have the ability to provide their own renter's insurance if they so choose. But I would, whatever the costs of that renter's insurance is, might as well, should be indicated.
Disclosed.
Yeah. If the landlord has to provide it. So Anonymous is pointing out that sites like apartments.com and other third-party sites don't allow 3 different rents to be listed in their advertisements.
So I think I'm going to piggyback on Rachel's answer just like a second ago. I presume this is because of the availability of the way a tenant can pay their rent, through direct deposit, credit card, or debit card. What you would do is list the rent with the highest amount and just say discounts applicable depending on the way rent is paid. Also, it's technically a discretionary fee because the tenant can just put in their rent amount, their bank account information locked in. So I stand corrected. Rachel, you rock.
Okay.
I think I say that to you every single webinar that I'm with.
This is why we have this rousing discussion. So if I'm wrong, I'm wrong. So yeah, the anonymous here has some concerns about treating ACH as a discount as well. And obviously, you are going to need to discuss everything with your own attorney if you have it, but there are certainly rental concessions that exist. Those are, those are options that already exist to landlords. So how you go about doing that, seek your own legal advice on those specifics.
I mean, I think, again, just to hone in on what the purpose of this statute is transparency, so that the tenant knows how much they're going to spend a month, and it has to be clear in the advertisement and on the lease. So if you're listing your unit, don't go with the lowest figure, because that's not honest. That's not what it's really going to cost.
Shayna, I think this was asked before you answered John's question earlier about the consequences of the landlord if they fail to comply, as to what the consequences are. So.
Yeah, okay. So, and if I'm not clear, what it is if you don't do a move-in and a move-out inspection and you have a security deposit and you charge $0, you're like, nope, I'm giving the whole thing back. I didn't do a move-in and move-out inspection. You have zero consequence. If you do a move-in, you fail to do a move-in or fail to do a move-out consequence and you withhold $500, there is a penalty of $500 for failing to do a move-in or a move-out inspection. So, and that's just considered separately from whether or not you could rightfully hold that $500. It's considered a penalty. So it's like you failed to do X under subdivision 4. It's the same penalty that if you fail to like send the check in 3 weeks, that you're wrong, that you have as a penalty. So it's under that same, matrix guideline. So definitely do it. Definitely keep a piece of paper that you did it. That's your proof that you complied with that section.
Right. To kind of piggyback out that, so now it's saying, do you think there will need to be 2 move-out inspections, one with the landlord and tenant, one with just the landlord after everything is out?
Completely up to your business practices and what makes sense. You definitely can do it 2 ways, where you have one on day 4 before they leave, one after they move out. You can also do it on the last day. So if the move out time is they need to be out by noon, you can say, and at noon we're meeting. So so we see what's going to be charged, what's going on here. Completely fine. Then you have only one time and you can maybe stagger how you do that. Completely up to you and your business practice around that.
Right, thank you. All right. This one is a good security deposit question that I think belongs on more like law school tests of how this works. So I'm assuming this is a landlord. So a tenant, another person gets added to a lease, or there are 2 people on a lease and one person moves out and one person stays. Who gets the security deposit? And go ahead.
Okay, well, I have my litigation position on this because I do this a lot working with college students.
I would be interested to hear what yours versus maybe, ours is. So,
well, my position very much is it does matter the most on how you collect that. So if you are collecting, if there's 5 people and 5 people paid you separately, that is 5 security deposits, even if it reached the same amount. So you have independent obligations to each one of those 5 people. If, however, you said we have one person that's moving out, they're signing a sublease, address that in your sublease paperwork. Address that in how you add that person on for how that is handled. And that's really where I see the conflict. But you want to be very clear, because the right to the security deposit is the tenant's right to the security deposit. I don't know if you guys have different opinions, and I always love to hear that.
No.
I can always be convinced I'm wrong.
We tend to, whoever, in this particular example, there would be one person who had paid the security deposit. And so it's their security deposit. If it's where 2 people pay the security deposit, it kind of falls into joint several liability. But on the flip of that coin, where, landlord can send it back, since they both signed the lease, landlord can send it back to one person and then they're supposed to split it, or landlord could split it between the 2.
What I generally tell tenants is security deposit stays with the unit, and then the people who are moving in and out can do the transfer of the money. I like to and I know that the issue is the interest, but the least people involved in the transaction, the
Mhm.
easier it is for everyone. So clearly there are quite a few options
Yeah.
on how to handle this.
Yeah, my suggestion was when like people move out at the same time,
Oh.
like a two people paid into a security deposit at move in and then they move out at the same time. Sorry. Seek legal advice on your particular situation from your own attorney. And yeah, as Shayna pointed out, like come to a consensus with your tenants, how do they want their security deposit back? Because they're supposed to give you their forwarding instructions as well. So that could be part of that conversation. All right, so we have some concerns about how fees are disclosed, and that is understandable. Because this, as Amma was saying, this is a new statute. And
Mhm.
so how this is gonna shake out is unknown still, right? Of how this looks, but this is an issue that's been going on. And so Amma, so the statute language doesn't specifically say that you can just give the prior high end amount for like the garbage and stuff.
Mhm.
Anonymous is also saying that
So
they're basically
let's
up to 10 separate rents to
right. So
disclose. Yeah.
let's give them one step at a time. So for the garbage issue, look at 504B.215 because that there's a specific statute that addresses how rate share utility billing happens, and so that's what's going to control that piece. In terms of the 10 separate rents, literally this is what this statute is trying to avoid. It would look absolutely ridiculous on an ad to have 10 different options, which is why it's easier to, if you have non-discretionary fees, you roll them into rent, and then discretionary fees are just listed as regular fees that the tenant has an option to take on or not. And then what was the last one? Oh, the cleaning fees and the carpet replacement.
Yeah, I hadn't.
Sorry.
You're getting ahead of me. Yeah, I guess the other option for the garbage one is don't charge your garbage that way.
Yeah. Don't do
Don't
rows.
separate it. Yeah, just do it as one. You know what your monthly garbage bill is as the landlord for the building, and you can roll that into your monthly rent.
Yeah.
So then our carpet replacement, carpet cleaning fees, mandatory versus not.
So if it's mandatory, the carpet cleaning fee, it's going to be charged regardless of whether you provide documentation or not. It's non-discretionary, so it has to be included in the rent amount. If you're saying tenant will charge X amount of money to clean the carpet unless you provide a receipt, and that really is a discretionary fee. And then carpet replacement, it really goes back, that just straight security deposit statute 504B.178. It goes to the standard of, is it beyond normal wear and tear? And then you can make deductions to the depreciated value of the carpet.
All right, so we are coming up on just about 5 minutes left. So we have a few questions, a few comments. We can get through them. But I want to make sure that folks know, again, we have more webinars coming up. This recording will be up in a couple of days on our website. And here is our information. All right. I want to see. Many times there are websites that will, I'm not quite certain I understand this question about housing authority apartment information without getting the actual information. If missing is if information is missing or incorrect. So are there consequences for not complying?
I don't think there are right now. I mean, I'm sure there will be. We don't know. I think this is talking about Housing Link, for example, that will list affordable housing through the housing authority. The information has to be present. Again, if you're going to rent the unit, you're going to do your advertisement, the information has to be there. I think ultimately what can happen is tenants can sue the landlord over these issues. And I'm sure the Attorney General will play a role in enforcing this.
Perfect.
Go ahead.
So there is some contention about whether 504B.215 overrides the new fee statute or not. So that is, again, there are options in place that you can, if you comply with 504B.215, the new statute was not intended to override any of the existing statutes. It's an
Correct.
addition and to work with them. Oh, a suggestion from a landlord. We have the leaving roommate sign a form relinquishing the deposit to the remaining leaseholders. That's one way of going about it as well. That's kind of what Shayna was talking about in her discussion. And I think, let's see, and if the tenants have the right to be there and the landlord feels that they need to have some sort of security fee there, is that a just mandatory fee or a discretionary fee? I feel that this is a little, tongue in cheek, but.
Yeah, I mean, it would be a mandatory fee if they don't have the option to walk out of it. And the thing is, the statute is saying that the tenant has the right to be present, correct, Shayna? So if it's a right the tenant has, you can't waive that right. They can't waive that right. And I guess you could hire security. And then that would be a mandatory fee if you're trying to pass on the cost to the tenant.
Yep. All right. Oh yeah, and Jessica is just linked to some of the recent information from the AG's office as part of a consent decree between Housing Hub and the Minnesota Attorney General regarding carpet cleaning fees and such. And I can drop that link to that decree, but basically Housing Hub had some mandatory cleaning fees that the Attorney General said that were not allowed, or that they would stop charging essentially as part of that consent decree. And we made it. We did it. Well done, everybody.
Yeah, in the nick of time.
Thank you very much, everyone, for joining us today. And again, this recording will be up. Have a wonderful rest of your day and take care, y'all. We'll see you next month. Bye.